Lim versus Executive Secretary, GR 151445. Facts. In the beginning of 2002, the personnel of Armed Forces of the United States started to arrive in the Philippines, which will participate in the Balikatan 021 pursuant to the VFA or Visiting Forces Agreement, signed in 1999. The Balikatan 021 is a stimulation of joint military maneuvers or exercises of Filipino and American, which was pursuant to MDT or Mutual Defense Treaty, a bilateral agreement entered into by the Philippine government and United States government in 1951. The entry of the American troops in the Philippines is partly rooted from the campaign of U.S. President George W. Bush against international terrorism as a result of terrorist attacks in the United States, which was the cause of numerous loss of lives. The petitioners, Arthur D. Lim and Paulino B. Ersando, as citizens, lawyers, and taxpayers, filed a petition for certiorari and prohibition and attacking the constitutionality of Balikatan 021, or the joint exercise. Subsequently, they were joined by Sanlakas and Partido ng Manggagawa by filing a petition in intervention. The claim that some of their members were situated in the places where the exercise are being conducted. However, the Solicitor General claimed that there were lack of locus standi, does not involve tax spending, and there is no proof of direct personal injury. Issue: whether or not the Balikatan 02 is covered by the VFA, whether or not the VFA is constitutional. Held: the VFA permits the U.S. personnel to engage on an impermanent basis in activities, the exact meaning of which was undefined. The permit under VFA grants U.S. personnel a wide scope of undertaking, subject only to approval of the Philippine government. In general, U.S. personnel must abstain from any activities inconsistent with the agreement, and in particular, from apolitical activities. All other activities, in other words, are fair game. In aid of the case at bar, the Vienna Convention on the Law of Treaties, Article 31 and 32, which contains the provisions governing the interpretation of international agreements. The cardinal rule of interpretation must involve an examination of the text, which is presumed to verbalize the intentions of the parties. The word activities, in the view of the court, it was deliberately made that way to give both parties leeway for negotiations. In this manner, the U.S. forces may sojourn in the territory of the Philippines for purposes other than military. Under these auspices, the VFA gives legitimacy to the current Balikatan exercises. It is only logical to assume that Balikatan 02, a mutual anti-terrorism, advising, assisting, and training exercises, falls under the context of the agreement. From the facts obtaining, the court finds that the Balikatan 02 joint military exercises has not intruded into the penumbra of error that would otherwise call for correction on the part of the court. The respondents did not commit grave abuse of discretion amounting to lack or excess of jurisdiction. Wherefore, the petition and petition in intervention are hereby dismissed without prejudice to the filing of new petition, sufficient in form and substance in the proper regional trial court. Kaluag versus Williams, juror number 47800. Facts. Maximo Kaluag, in his capacity as a private citizen and a taxpayer of Manila, filed a petition for a writ of prohibition against the respondents. It is alleged in the petition that the National Traffic Commission, in its resolution of July 17, 1940, resolved to recommend to the Director of the Public Works and to the Secretary of Public Works and Communications that animal-drawn vehicles be prohibited from passing along Rosario Street, extending from Plaza Calderon de la Barca to Dasmariñas Street from 7:30 to 12:30 p.m., 7:30 a.m. to 12:30 p.m., and from 1:30 p.m. to 5:30 p.m., and along Rizal Avenue, extending from Railroad Crossing at Antipolo Street to Echage street from 7 a.m. to 11 p.m. for a period of 1 year from the date of the opening of the Colgante Bridge to traffic. The chairman of the National Traffic Commission on July 18, 1940, recommended to the Director of Public Works, with the approval of the Secretary of Public Works, the adoption of the measure proposed in the resolution aforementioned in pursuance of the provisions of the Commonwealth Act No. 548, which authorizes said director, with the approval from the Secretary of the Public Works and Communication, to promulgate rules and regulations to regulate and control the use of and traffic on national roads. On August 2, 1940, the Director recommended to the Secretary the approval of the recommendation made by the Chairman of the National Traffic Commission, with modifications. The Secretary of Public Works approved the recommendations on August 10, 1940. The Mayor of Manila and the Acting Chief of Police of Manila have enforced and caused to be enforced the rules and regulation. As a consequence, all animal-drawn vehicles are not allowed to pass and pick up passengers in the places above mentioned, to the detriment not only to their owners but of the riding public as well. Issue: whether the rules and regulations promulgated by the respondents pursuant to the provisions of Commonwealth Act 548 constitute an unlawful inference with legitimate business or trade and abridge the right to personal liberty and freedom of locomotion. Number 2, whether the rules and regulations complained of infringe upon the constitutional precept regarding the promotion of social justice to ensure the well-being and economic security of all the people. Held. Number 1. No, the promulgation of the Act aims to promote safe transit upon and avoid obstruction on national roads in the interest and convenience of the public. In enacting said law, the National Assembly was prompted by considerations of public convenience and welfare. It was inspired by the desire to relieve congestion of traffic, which is a menace to public safety. Public welfare lies at the bottom of the promulgation of the said law, and the state, in order to promote the general welfare, may interfere with personal liberty, with property, and with business and occupations. Persons and property may be subject to all kinds of restraints and burdens in order to secure the general comfort, health, and prosperity of the state. To these fundamental aims of the government, the rights of the individual are subordinated. Liberty is a blessing which should not be made to prevail over authority, because society will fall into anarchy. Neither should authority be made to prevail over liberty, because then the individual will fall into slavery. The paradox lies in the fact that the apparent curtailment of liberty is precisely the very means of ensuring its preserving. Number 2. No, social justice means the promotion of the welfare of all the people. The adoption by the government of measure calculated to ensure economic stability of all the competent elements of society through the maintenance of a proper economic and social equilibrium in the interrelations of the members of the community, constitutionally through the adoption of measures legally justifiable, or extra-constitutionally through the exercise of powers underlying the existence of all governments on the time-honored principle of salus populi as suprema lex. Social justice must be founded on the recognition of the necessity of interdependence among diverse units of a society, and of protection that should be equally and evenly extended to all groups as a combined force in our social and economic life, consistent with the fundamental and paramount objective of the state of promoting health, comfort, and quiet of all persons, and of bringing about the greatest good to the greatest number. The petition is denied with cost against petitioner. Philippine Telegraph and Telephone versus NLRC, GR 118978. Facts: seeking relief through the extraordinary writ of certiorari, petitioner Philippine Telegraph and Telephone Company, hereafter PT&T, invokes the alleged concealment of civil status and defalcation of company funds as grounds to terminate the services of an employee. That employee, herein private respondent Grace de Guzman, contrarily argues that what really motivated PT&T to terminate her services was her having contracted marriage during her employment, which is prohibited by petitioner in its company policies. She thus claims that she was discriminated against in gross violation of law, such a proscription by an employer being outlawed by Article 136 of the Labor Code. Issue whether or not the policy of not accepting or considering as disqualified from work any woman worker who contracts marriage is valid. Held, petitioner's policy of not accepting or considering as disqualified from work any woman worker who contracts marriage runs afoul of the test of and the right against discrimination afforded all women workers by our labor laws and by no less than the Constitution. The Constitution, cognizant of the disparity in rights between men and women, in almost all phases of social and political life, provides a gamut of protective provisions. Acknowledged as paramount in the due process scheme is a constitutional guarantee of protection to labor and security of tenure. Thus, an employee is required as a condition sine qua non prior to severance of the employment ties of an individual under his employ to convincingly establish through substantial evidence the existence of a valid and just cause in dispensing with the services of such employee, one's labor being regarded as constitutionally protected property. The government, to repeat, abhors any stipulation or policy in the nature of that adopted by petitioner PT&T. The Labor Code states in no uncertain terms as follows. Article 136, Stipulation against marriage. It shall be unlawful for an employer to require as a condition of employment or continuation of employment that a woman shall not get married, or to stipulate expressly or tacitly that upon getting married a woman employee shall be deemed resigned or separated, or to actually dismiss, discharge, discriminate, or otherwise prejudice a woman employee merely by reason of marriage. In the case at bar, it can easily be seen from the memorandum sent to private respondent by the branch supervisor of the company, with a reminder that you're fully aware that the company is not accepting married women employee, as it was verbally instructed to you. Open and close parenthesis. Again, in the termination notice sent to her by the same branch supervisor, private respondent was made to understand that her severance from the service was not only by reason of her concealment of her married status, but over and on top of that was her violation of the company's policy against marriage, and even told you that married women employees are not applicable or accepted in our employment. Open and close parenthesis. Petitioner's policy is not only in derogation of the provisions of Article 136 of the Labor Code on the right of a woman to be free from any kind of stipulation against marriage in connection with her employment, but it likewise assaults good morals and public policy, tending as it does to deprive a woman of the freedom to choose her status, a privilege that by all accounts inheres in the individual as an intangible and inalienable right. Hence, while it is true that the parties to a contract may establish any agreements, terms, and conditions that may deem convenient, the same should not be contrary to law, morals, good custom, public order, or public policy. Carried to its logical consequences, it may even be said that petitioner's policy against legitimate marital bonds would encourage illicit or common law relations and subvert the sacrament of marriage. Philippine Association of Service Exporters, or PASEI, versus Franklin Drilon, GR 81958. Facts: Petitioner, Philippine Association of Service Exporters Incorporation, a firm engaged principally in the recruitment of male and female Filipino workers for overseas employment. Respondents are Franklin Drilon as Secretary of Labor and Employment, and Thomas Acacoso as POEA Administrator. Petitioner challenges the constitutional validity of Dole Department Order No. 1 regarding the temporary suspension of deployment of Filipino domestic and household workers. The said order is being questioned particularly for the following grounds: the discrimination against males or females, that it applies only to female domestic helpers and not to all Filipino workers, a violation of the right to travel, and more importantly, an invalid exercise of police power. Issue whether or not Department Order Number 1 is valid under the Constitution. Held yes. The Supreme Court said that it is admitted that the assailed order is in the nature of a police measure and police power is in the domain of the legislature, but it does not mean that such an authority may not be lawfully delegated, as in this case, the Department of Labor and Employment is vested with such authority by the Labor Code. Police power has been defined as the state authority to enact legislation that may interfere with personal liberty or property in order to promote the general welfare. As a general rule, official acts enjoy presumed validity, and in the absence of clear and convincing evidence to the contrary, the presumption logically stands. The Supreme Court also said that it being the caretaker of a constitutional right, the court is called upon to protect victims of exploitation, and in fulfilling that duty, it must sustain the government's effort. Discrimination in this case is justified. Lastly, the court understands the impact this order would have on the business of recruitment, but the concern of the government is not to maintain profits of business firms which suffer because of governmental regulation, but rather to provide a decent living to its citizens. The petitioner has shown no satisfactory reason why the contested measure should be nullified. There is no question that Department Order Number 1 applies only to female contract workers, but it does not thereby make an undue discrimination between the sexes. It is well settled that equality before the law under the Constitution does not import a perfect identity of rights among all men and women. It admits of classifications, provided that such classification rests on substantial distinction. 2. They are germane to the purposes of the law. 3. They are not confined to existing conditions. And 4. They apply equally to all members of the same class. The court is satisfied that the classification made the preference for female workers rests on substantial distinctions. Imbong versus Ochoa, GR number 204819. Facts: Republic Act number 10354, otherwise known as the Responsible Parenthood and Reproductive Health Act of 2012, RH Bill Law, was enacted by Congress on December 21, 2012. Challengers from various sectors of society are questioning the constitutionality of the said act. The petitioners are assailing the constitutionality of RH law on the following grounds: substantial issues. The RH law violates the right to life of the unborn. The RH law violates the right to health and the right to protection against hazardous products. The RH law violates the right to religious freedom. The RH law violates the constitutional provision of involuntary servitude. It violates the right to equal protection of law. It violates the right to free speech. It is a void for vagueness in violation of the Due Process Clause of the Constitution. And finally, the RH law intrudes into the zone of privacy of one's family protected by the Constitution. Procedural: whether the court may exercise its power of judicial review over the controversy. Number 1, power of judicial review. 2, actual case or controversy. 3, facial challenge. 4, locus standi. 5, declaratory relief. And 6, one subject, one trial title rule. Issues: substantial issues, whether or not RA 10354 or reproductive health RH law is unconstitutional for violating the following: right to life, right to health, freedom of religion, right to free speech, right to privacy, marital privacy and autonomy, freedom of expression and academic freedom, due process of clause, equal protection of clause. Discussions: procedural, judicial review. Jurisprudence is replete with a rule that the power of judicial review is limited by 4 exacting requisites: A. There must be an actual case or controversy. B. The petitioners must possess locus standi. C. The question of constitutionality must be raised at the earliest opportunity. And D. The issue of constitutionality must be the lis moda of the case. Actual controversy. An actual case or controversy means an existing case or controversy that is appropriate or ripe for determination, not conjunctural or anticipatory, lest the decision of the court would amount to an advisory opinion. It must concern a real, tangible, and not merely a theoretical question or issue. There ought to be an actual and substantial controversy admitting of specific relief through a decree conclusive in nature, as distinguished from an opinion advising what the law would be upon a hypothetical state of facts. Corollary to the requirement of actual case or controversy is the requirement of ripeness. A question is ripe for adjudication when the act being challenged has had a direct adverse effect on the individual challenging it. For a case to be considered ripe for adjudication, it is a prerequisite that something has then been accomplished or performed by either branch before a court may come into the picture, and the petitioner must allege the existing of an immediate or threatened injury to himself as a result of the challenged opinion action. He must show that he has sustained or is immediately in danger of sustaining some direct injury as a result of the act complained of. Facial challenge. A facial challenge, also known as the First Amendment challenge, is one that is launched to assail the validity of statutes concerning not only protected speech, but also all other rights in the First Amendment. This includes religious freedom, freedom of the press, the right of the people peaceably assemble, and to petition the government for a redress of grievances. After all, the fundamental right to religious freedom, freedom of the press, and peaceful assembly are but component rights of the rights to one's freedom of expression, as they are modes which one's thoughts are externalized. Locus standi. Locus standi, or legal standing, is defined as a personal and substantial interest in a case such that the party has sustained or will sustain direct injury as a result of the challenged governmental act. It requires a personal stake in the outcome of the controversy as to assure the concrete adverseness, which sharpens the presentation of issues upon which the court so largely depends for elimination of difficult constitutional questions. Transcendental importance. The court leans on the doctrine that the rule on standing is a matter of procedure, hence can be relaxed for non-traditional plaintiffs like ordinary citizens, taxpayers, and legislators when the public interest so requires, such as when the matter is of transcendental importance, of overreaching significance to society, or of paramount public interest. One subject, one subject, one title. The one title, one subject rule does not require the Congress to employ in the title of the enactment language of such precision as to mirror, fully index, or catalog all the contents and the minute details therein. The rule is sufficiently complied with if the title is comprehensive enough as to include the general object which the statute seeks to effect, and where, as here, the persons interested are informed of the nature, scope, and consequences of the proposed law and its operation. Moreover, this court has invariably adopted a liberal rather than technical construction of the rule, so as not to cripple or impede legislation. The one subject, one title rule expresses the principle that the title of a law must not be so uncertain that the average person reading it would not be informed of the purpose of the enactment or put on inquiry as to its contents, or which is misleading either in referring to or indicating one subject where another or different one is really embraced in the act, or in omitting any expression or indication of the real subject or scope of the act. Declaration of unconstitutionality. Orthodox view: an unconstitutional act is not a law. It confers no right, it imposes no duties, it affords no protection, it creates no office. It is in legal contemplation as inoperative as though it had never been passed. Modern view. Under this view, the court, in passing upon the question of constitutionality, does not annul or repeal the statute if it finds it in conflict with the Constitution. It simply refuses to recognize it and determines the right of the parties, just as if such statute had no existence, but certain legal effects of the statutes prior to its declaration of unconstitutionality may be recognized. Requisites for partial unconstitutionality. Number 1. Legislature must be willing to retain the valid portions, usually shown by the presence of a separability clause in the law, and 2. The valid portion can stand independently as law. Ruling. Substantial. Majority of the members of the court believe that the question of when life begins is a scientific and medical issue that should not be decided at this stage without proper hearing and evidence. However, they agree that individual members could express their own views on this matter. Article 2, Section 12 of the Constitution states, "The state recognizes the sanctity of family life and shall protect and strengthen the family as a basic autonomous social institution. It shall equally protect the life of the mother and the life of the unborn from conception." In its plain and ordinary meaning, a canon in statutory construction, the traditional meaning of conception, according to reputable dictionaries cited by the ponente, is that life begins at fertilization. Medical sources also support the view that conception begins at the fertilization. The framers of the Constitution also intended for conception to refer to the moment of fertilization, and b. the protection of the unborn child upon fertilization. In addition, they did not intend to ban all contraceptives for being unconstitutional. Only those that kill or destroy the fertilized ovum would be prohibited. Contraceptives that actually prevent the union of the male sperm and the female ovum, and those that similarly take action before fertilization, should be deemed non-abortive and thus constitutionally permissible. The intent of the framers of the Constitution for protecting the life of the unborn child was to prevent the legislature from passing a measure to prevent abortion. The court cannot interpret this otherwise. The RH law is in line with this intent and actually prohibits abortion by using the word "or" in defining abortifacient. Section 4. The RH law prohibits not only drugs or devices that prevent implantation, but also those that induce abortion and induce the destruction of a fetus inside the mother's womb. The RH law recognizes that the fertilized ovum already has life and that the state has a bounden duty to protect. However, the authors of the IRR gravely abused their office when they redefined the meaning of abortifacient by using the term primarily, recognizing as abortifacients only those that primarily induce abortion or the destruction of a fetus inside the mother's womb, or the prevention of the fertilized ovum to reach and be implanted in the mother's womb. Section 3(1)(a) of the IRR would pave the way for the approval of contraceptives that may harm or destroy the life of the unborn from conception or fertilization. This violates Section 12, Article 2 of the Constitution. For the same reason, the definition of contraceptives under IRR, which also uses the term primarily, must be struck down. The RH law does not intend to do away with RA 4729. With RA 42729 in place, the court believes adequate safeguard exists to ensure that only safe contraceptives are made available to the public. In fulfilling its mandate under Section 10 of the RH law, the DOH must keep in mind the provisions of RA 4729. The contraceptives it will procure shall be from a duly licensed drug store or pharmaceutical company, and that the actual distribution of these contraceptives, drugs, and devices will be done following a prescription of a qualified medical practitioner. Meanwhile, the requirement of Section 9 of the RH law is to be considered mandatory only after these devices and materials have been tested, evaluated, and approved by the FDA. Congress cannot determine that contraceptives are safe, legal, non-abortifacient, and effective. The court cannot determine whether or not the use of contraceptives or participation in support of modern RH measures is a. moral from a religious standpoint, b. right or wrong according to one's dogma or belief. However, the court has the authority to determine whether or not the RH law contravenes the constitutional guarantee of religious freedom. The state may pursue its legitimate secular objectives without being dictated upon the policies of any one religion. To allow religious sects to dictate policy or restrict other groups would violate Article 3, Section 5 of the Constitution, or the Establishment Clause. This would cause the state to adhere to a particular religion and thus establishes a state religion. Thus, the state can enhance its population control program through the RH law, even if the promotion of contraceptive use is contrary to the religious beliefs of the petitioner. Section 4, Section 23A2 of the RH law, which permits RH procedures even with only the consent of the spouse undergoing the provision, disregarding spousal consent, intrudes into marital privacy and autonomy and goes against the constitutional safeguards of the family as the basic social institution, particularly Section 3, Article 15 of the Constitution mandates the state to defend a. the right of spouses to found a family in accordance with their religious convictions and the demands of responsible parenthood, and b. the right of families or family associations to participate in the planning and implementation of policies and programs that affect them. The RH law cannot infringe upon this mutual decision making and endanger the institutions of marriage and the family. The exclusion of parental consent in cases where a minor undergoing a procedure is already a parent or has had a miscarriage, Section 7 of the RH law, is also anti-family and violates Article 2, Section 12 of the Constitution, which states the natural and primary right and duty of parents in the rearing of the youth for civic efficiency and the development of moral character shall receive the support of the government. In addition, the portion of Section 23A, number 2, which reads, in the case of minors, the written consent of parents or legal guardian, or in their absence, persons exercising parental authority, or next of kin, shall be required only in elective surgical procedures, is invalid as it denies the right of parental authority in cases where what is involved is non-surgical procedures. However, a minor may receive information as opposed to procedures about family planning services. Parents are not deprived of parental guidance and control over their minor child in this situation and may assist her in deciding whether to accept or reject the information received. In addition, an exception may be made in life-threatening procedures. The court declined to rule on the constitutionality of Section 14 of the RH law, which mandates the state to provide age and development appropriate reproductive health education. Although educators might raise their objection to their participation in the RH education program, the court reserves its judgment should an actual case be filed before it. Any attack on its constitutionality is premature because the Department of Education has not yet formulated a curriculum on age-appropriate reproductive health education. Section 12, Article 2 of the Constitution places more importance on the role of parents in the development of their children with the use of the term primary. The right of parents in upbringing their youth is superior to that of the state. The provisions of Section 14 of the RH law and corresponding provisions of the IRR supplement rather than supplant the right and duties of the parents in the moral development of their children. By incorporating parent-teacher community associations, school officials, and other interest groups in developing the mandatory RH program, it could very well be said that the program will be in line with the religious belief of the petitioners. The RH law does not violate the due process clause of the Constitution, as the definitions of several terms as observed by the petitioners are not vague. The definition of private health care service provided must be seen in relation to Section 4 of the RH law, which defines a public health service provider. The private health care institution cited under Section 7 should be seen as synonymous to private health care service provider. The term service and methods are also broad enough to include providing for information and rendering of medical procedures. Thus, hospitals operated by religious groups are exempted from rendering RH services and modern family planning methods as provided for the Section 7 of the RH law, as well as from giving RH information and procedures. The RH law also defines incorrect information. Also together in relation to Section 23, the terms incorrect and knowingly connote a sense of malice and ill motive to mislead or misrepresent the public as to the nature and effect of programs and services on reproductive health. To provide that the poor are to be given priority in the government's RH program is not a violation of the Equal Protection Clause. In fact, it is pursuant to Section 11, Article 13 of the Constitution, which states that the state shall prioritize the needs of the underprivileged, sick, elderly, disabled, women, and children, and that it shall endeavor to provide medical care to paupers. Accordingly, the court declares RA number 10354 as not unconstitutional except with respect to the following provisions which are declared unconstitutional. Section 7 of the corresponding provision in the RHIRR insofar as they A. require private health facilities and not maternity specialty hospitals and hospitals owned and operated by a religious group to refer patients not in an emergency or life-threatening case as defined under Republic Act number 8344 to another health facility which is conveniently accessible, and B. allow minor parents or minors who have suffered a miscarriage access to modern methods of family planning without written consent from their parents or guardians. Number 2, Section 23, letter A and letter L, and the corresponding provisions in the RHIRR, particularly Section 5, number 24 thereof, insofar as they punish any healthcare service provider who fails and or refuses to disseminate information regarding programs and services on reproductive health regardless of his or her religious belief. Number 3, Section 23, letter A, number 2, letter I, and the corresponding provisions in the RHIRR insofar as they allow a married individual not in an emergency or life-threatening case as defined under Republic Act number 8344 to undergo reproductive health procedures without the consent of the spouse. Number 4, Section 23A, number 2, II, and the corresponding provision in the RHIRR insofar as they limit the requirements of parental consent only to elective surgical procedures. Number 5, Section 23, letter A, number 3, and the corresponding provision in the RHIRR, particularly Section 5, number 24 thereof, insofar as they punish any healthcare service provider who fails or refuses to refer a patient not in an emergency or life-threatening case as defined under Republic Act number 8344 to another healthcare service provider within the same facility or one which is conveniently accessible regardless of his or her religious belief. Number 6, Section 23, letter B, and the corresponding provision in the RHIRR, particularly Section 5, 24 thereof, insofar as they punish any public officer who refuses to support reproductive health programs or shall do any act that hinders the full implementation of a reproductive health program, regardless of his or her religious belief. Number 7, Section 17 of the corresponding provisions in the RHIRR regarding the rendering of pro bono reproductive health service insofar as they affect the conscientious objector in securing PhilHealth accreditation. And number 8, Section 301A and Section 301G of the RHIRR, which added the qualifier primarily in defining abortifacients and contraceptives as they are ultra-vires and therefore null and void for contravening Section 4A of the RH law and violating Section 12, Article 2 of the Constitution. Pamatong versus Comelec, GR number 161872. Facts. Petitioner Pamatong filed his certificate of candidacy for president. Respondent Comelec declared petitioner and 35 others as nuisance candidates who could not wage a nationwide campaign and or not nominated by a political party or are not supported by registered political party with a national constituency. Pamatong filed a petition for writ of certiorari the Supreme Court claiming that the Comelec violated his right to equal access to opportunities for public service under Section 26, Article 2 of the 1987 Constitution by limiting the number of qualified candidates only to those who can afford to wage a nationwide campaign and or are nominated by political parties. The Comelec supposedly erred in disqualifying him since he is the most qualified among all the presidential candidates. He possesses all the constitutional and legal qualifications for the office of the president. He is capable of waging a national campaign since he has numerous national organizations under his leadership. He also has the capacity to wage an international campaign since he has practiced law in the other countries and he has a platform for government. issue whether or not the petitioner's interpretation of the constitutional provision under Section 26, Article 2 gives him a constitutional right to run or hold for public office. Ruling, no. What is recognized in Section 26, Article 2 of the Constitution is merely a privilege subject to limitations imposed by law. It neither bestows such a right nor elevates the privilege to the level of an enforceable right. There is nothing in the plain language of the provision which suggests such a trust or justifies an interpretation of the sort. The equal access provision in a subsumed part of Article 2 of the Constitution entitled Declaration of Principles and State Policies. The provisions under the article are generally considered not self-executing, and there is no plausible reason for according a different treatment to the equal access provision. Like the rest of the policies enumerated in Article 2, the provision does not contain any judicially enforceable constitutional right but merely specify the guideline for legislative or executive action. The disregard of the provision does not give rise to any cause of action before the courts. Obviously, the provision is not intended to compel the state to enact positive measures that would accommodate as many people as possible into public office. Moreover, the provision as written leaves much to be desired if it is to be regarded as the source of positive rights. It is difficult to interpret the clause as operative in the absence of legislation, since its effective means and reach are not properly defined. Broadly written, the myriad of claims that can be subsumed under this rubric appear to be entirely open-ended. Words and phrases such as equal access, opportunities, and public service are susceptible to countless interpretation owing to their inherent impreciseness. Certainly, it was not the intention of the framers to inflict on the people an operative but an amorphous foundation from which innately an enforceable right may be sourced. The privilege of equal access to opportunities to public office may be subjected to limitations. Some valid limitations, specifically on the privilege to seek elective office, are found in the provisions of the Omnibus Election Code on nuanced candidates, as long as the limitations apply to everybody equally without discrimination. However, the Equal Access Clause is not violated. Equality is not sacrificed as long as the burdens engendered by the limitations are meant to be borne by anyone who is minded to file a certificate of candidacy. In the case at bar, there is no showing that any person is exempt from the limitations or the burdens which they create. The rationale behind the prohibition against nuanced candidate and the disqualification of candidates who have not evinced a bona fide intention to run for office is easy to divine. The state has a compelling interest to ensure that its electoral exercises are rational, objective, and orderly. Towards this end, the state takes into account the practical considerations in conducting elections. Inevitably, the greater the number of candidates, the greater the opportunities for logistical confusion, not to mention the increased allocation of time and resources in preparation for the election. The organization of an election with bona fide candidates standing in is onerous enough. To add into the mix candidates with no serious intentions or capabilities to run a viable campaign would actually impair the electoral process. This is not to mention the candidacies which are palpably ridiculous so as to constitute a one-note joke. The poll body would be bogged by irrelevant miniature covering every step of the electoral process, most probably post at the instance of these nuanced candidates. It would be a senseless sacrifice on the part of the state. The question of whether a candidate is a nuisance candidate or not is both legal and factual. The basis of the factual determination is not before this court. Thus, the remand of this case to the reception of further evidence is in order. The Supreme Court remanded to the Comelec for the reception of further evidence to determine the question on whether petitioner Eli Velez Lao Pamatong is a nuisance candidate as contemplated in Section 69 of the Omnibus Election Code. Lina versus Pano, GR 129093. Facts. On December 29, 1995, Respondent Tony Calvento was appointed agent by the Philippine Charity Sweepstakes Office to install Terminal OM20 for the operation of Lotto. He asked Mayor Calixto Katakis, Mayor of San Pedro, Laguna, for a mayor's permit to open Lotto outlet. This was denied by the Mayor Kadakis on the ground that an ordinance was passed by the Sangguniang Panlalawigan of Laguna entitled Kapasiyahan Bilang 508 T 1995, which read isang kapasiyahan, tinututulan ang mga illegal gambling, lalo na ang loto sa lalawigan ng Laguna. As a result of denial, Respondent Calvento filed a complaint for declaratory relief with prayer for preliminary injunction and temporary restraining order. Petitioner contended that, number 1, the assailed resolution is a valid policy declaring of the provincial government of Laguna of its vehement objection to the operation of Lotto and all forms of gambling. Number 2, it is likewise a valid exercise of the provincial government's police power under the General Welfare Clause of RA 7160, otherwise known as the Local Government Code of 1991. 3, they also maintain that respondent's Lotto operation is illegal because no prior consultation and approval by the local government were sought before it was implemented, contrary to the express provision of Section 2, letter C, and 27 of RA 7160. For his part, Respondent Calvento argues that the resolution is in effect a curtailment of the power of the state, since it is, in this case, the national legislature itself had already declared Lotto as legal. As for the allegation that no prior consultations and approval were sought from the Sangguniang Panlalawigan of Laguna, Respondent stated as a declaration of policy and not a self-executing provision of LGC of 1991. The respondent Judge Francisco Pano promulgated his decision enjoining the petitioners from implementing or enforcing resolution of Kapisiyahan Bilang 508 T 1995. Motion for reconsideration was denied. Thus, petitioners filed petition for review on certiorari issues whether Kapisiyahan Bilang 508 T 1995 of Sangguniang Panlalawigan of Laguna and a denial of mayor's permit based thereon are valid, whether prior consultation and approval by the concerned Sanggunian are needed before a Lotto system can be operated in a given local government unit. Ruling: the petition is denied. The court ruled that the ordinance merely states the objection of the council to said game. It is but a mere policy statement on the part of the local council, which is not self-executing, nor could it serve as a valid ground to prohibit the operation of the Lotto system in the province of Laguna. As a policy statement expressing the local government's objection to the Lotto, such resolution is valid. This is part of the local government's autonomy to air its views, which may be contrary to that of the national governments. However, this freedom to exercise contrary views does not mean that local governments may actually enact ordinances that go against laws duly enacted by Congress. Given this premise, the assailed resolution in this case could not and should not be interpreted as a measure of or ordinance prohibiting the operation of Lotto. As for the second issue, court ruled that petitioners erred in declaring that Section 2, letter C, and 27 of RA 7160 apply mandatorily in the setting up of Lotto outlets around the country. From careful reading of said provisions, the court finds that these apply only to national programs and or projects which are to be implemented in a particular local community. Local is neither a program nor a project of the national government, but of a charitable institution, the PCSO. Though sanctioned by the national government, it is far-fetched to say that Lotto falls within the contemplation of Section 2, letter C, and 27 of the Local Government Code.